Welcome to our DataGuard interview, exclusive insights, privacy trends, and hot topics. My name is Dr. Frank Schemmel, and I have the honor to be your host today. In January, every privacy professional gets excited as there is International Data Protection Day. And we here at DataGuard, we celebrate this with an entire data privacy week full of content and initiatives. The highlight of our celebration is this expert interview. And speaking of highlights, I'm very delighted to introduce our guest today, although he does not need much intro as he's one of the most active voices in privacy in the DACH region. Dr. Carlo Piltz, partner at Piltz Legal, multi-time awarded privacy lawyer and editor-in-chief for the magazine Datenschutzberater. Hi, Carlo. Welcome to our interview today.
Hi, Frank. Thanks for having me.
Yeah. Are you excited about what this year brings in terms of data protection?
Absolutely. That's the great thing in the data protection bubble, that we never know what awaits us in the next 12 months. And judging by looking back to the past 12 months will be an interesting year for us.
I absolutely agree. And since 2023 just started, Carlo, as he mentioned, and I will take a brief look back into 2022 and the current state of data protection, but we will also try to look into the crystal ball and discuss what we deem as trends and hot topics in 2023. And inter alia will cover international data transfers as a never-ending story, as well as regulatory and supervisory activities. So are you ready to ramble, Carlo?
Sure, let's go.
Okay, then let's start with the first topic, and I just mentioned it. The topic of international data transfers has been a permanent guest on the agenda of privacy professionals across the globe. Since the CJEU, the Court Justice of the European Union, overturned the Privacy Shield 2.5 years ago in its infamous Schrems II decision. And to be honest, it was not easy to deal with the aftermath in practice, right? The legally compliant design of data transfers from Europe to the USA, in my opinion, was one of the most frequent, complex, and time-consuming issues that data protection officers, so the DPOs, in organizations and legal advisors like Carlo had to deal with over the last 2.5 years. Would you agree, Carlo?
Yeah, that's true. Absolutely. The issue of international data transfers has kept us all very busy in 2022, not least, just to give you one example, because the old standard contractual clauses no longer apply since end of December. And let's say in an ideal world, all organizations had to switch to the new standard contractual clauses already. Just this process was time consuming. And I think also in this year, it will still be on the agenda for all of us.
Yeah, I mean, we see as well within our customers that still some of them haven't realized that they had to switch, and to some extent it's a very cumbersome process because I mean there are a lot of contracts in place for years or even a decade, right? That you have to adapt, and it's not easy to find out what kind of contracts are in place actually, and what do I have to change.
Yeah, that's true. It's already just to acknowledge the fact that you have to do something, that you have to search for the contracts, that you have to receive the information from your organization. Who do I have contracts with? Who I'm transferring data to? That's already the first, and as you mentioned, burdensome step.
It is. Aside from that, if you look back, and maybe I had, but I hope things would change. What has been the trickiest part in your daily consulting practice in terms of international data transfers ever since the Schrems II ruling?
Yeah, I think that's difficult question to answer because there were a lot of difficult issues and problems to solve with regard to international data transfers. From my opinion, or also in my experience, it was, as mentioned, sometimes difficult at first to make people aware of the issue and of the relevance of this topic. Or to put it in other words, perhaps for people, organizations, companies to see, okay, I have to take action now. I have to do something about it. In addition, another issue was definitely the conclusion of the new standard contractual clauses and the negotiations on the new standard contractual clauses, in particular also with the obligation to conduct the transfer impact assessment, the so-called TIA. This was sometimes a difficult issue in practice because all of us, we don't have like the blueprint for a TIA, for a transfer impact assessment. No one knows 100% for sure what has to be in the TIA. And in practice, as an EU exporter of personal data, you were dependent on the cooperation of the importer in third countries, not only the US, but also other third countries. And sometimes, in my experience, this was unfortunately not always so easy to cooperate with third country organizations and to receive the relevant information for the tiers.
Yeah, I would agree. In particular, in terms of TIA, we all would agree that our lives would have been easier if the supervisory authorities published more information on that. I mean, there is for all of you out there. There is a TIA conducted by the CJEU, right, on Cisco WebEx, and I mean the CJEU is the one to rule, if it comes to that, how a TIA should look like or would look like. And if you take that as a blueprint, I think you cannot do much wrong.
Exactly, yeah. That's also something we do for our practice. We copied the relevant parts of the tier from the Court of Justice, even more since the European Data Protection Supervisor acknowledged this tier and accepted this tier for Cisco WebEx. So that's, I think, a very good information for colleagues in practice, yeah.
And we have to say, fortunately, a lot of things happened in terms of a successor to the Privacy Shield. In particular, at the end of last year, I mean, first things, the Biden administration published the long-awaited executive order and additional information on how the US side will cope with the requirements stipulated by the CJEU and the European Data Protection Board, the EDPB. And that shortly followed by the EU Commission taking that into account and incorporating those commitments into a draft adequacy decision. And it was a really early Christmas present and not expected by many of us. But what could have been expected, and it also took place, is that shortly after discussions began in the data protection community as to whether the measures promised by the US were sufficient to meet the high requirements of the CJEU. So many of us still wonder, will this be the final chapter or continue as a never ending story? Carlo, do you think the efforts made in the EO, in the executive order, and the adequacy decision in the draft meet the requirements stipulated by the CJEU in its safe harbor? and Schrems II rulings. We must not forget the safe harbor ruling as well, right? It has it includes very important requirements as well.
Yeah, I hope so, that it will fulfill the requirements of the Court of Justice. But to be honest, I don't know, nor would I presume to predict it with certainty if the future privacy framework will fulfill all the requirements. And because, as you know, in its ruling, the European Court of Justice did not draw up a checklist where we could just tick boxes, or the European Commission could tick boxes and like do their homework and publish a new decision, and that's it. So I think we will have to wait and see how the final text of the Commission decision looks like, and then we have to wait and see how the European Court of Justice reacts. I mean, we could, with an ironic view, say, okay, we are currently used to already 2 decisions invalidating a European Commission adequacy decision, so why not a third one? But of course, for organizations in practice, at least some time of certainty would also be nice. And I also think, after all, from the organizations, from the controllers or also processors point of view, you can change the text of the privacy framework by the Commission, and also not the text of the executive order itself. So you have to work with what we will be, or what will come, and what will be put into effect in the end. But once the decision is there, it will certainly be a little more relaxed, for at least for data transfers to the US and companies participating in the self-certification process, at least for a certain time. And since the decision also binds the data protection authorities in the EU, of course, only until European Court of Justice decides the third time.
I fully agree. I mean, usually all good things come in 3, but we all hope that this doesn't happen. But I mean, Max Schrems and his organization, None of Your Business, they already announced that they took a deep look into the draft decision and will do so when the final text is out there, and likely challenge the new framework before court as well. So as per usual, whether it is merely old wine in new bottles will ultimately be decided again by the CJEU. And as you already mentioned as well, the supervisory authorities here in Europe, they are bound by that. I mean, some of them, in particular German ones, they commented on the executive order and the draft adequacy decision, and provided their point of view, but were to some extent also very critical, which is legit to some extent, but also, I mean, they cannot do much about that. One point I want to really point out here to our viewers and listeners is one of the most criticized points in the new framework is the new complaint mechanism. It has been criticized a lot, and just to give you a brief summary to those of you who are not familiar with it yet, it is now or it will be a 2-layer redress mechanism. So there's a first layer where EU individuals will be able to lodge a complaint with a so-called civil liberties protection officer who sits in the US intelligence community. And in a second layer, EU individuals would then have the right to appeal that decision to a newly created data protection review court. And in my opinion, I mean, it's completely different from the previous privacy shield ombudsperson, which was, I think, Carlo, you agree, was very lame and ineffective in practice. And it is a huge step and commitment of the US administration to have some redress mechanism like this enacted. Whether it is effective or not, time will tell and prove. But I think it's still much more than we had before.
Yeah, definitely. I think we all see that, or we all knew after the European Court of Justice decision that to some extent the laws or the landscape in the US has to change in order to comply with the European Court of Justice requirements or the deficiencies the court pointed to. And so what we saw is this movement by the via the executive order, which I was a little bit surprised that the Americans had really moved and took that step forward towards European Union requirements. And in the end, we have to see if it's enough for the European Court of Justice, if this new mechanism will fulfill the requirements. We don't know. But as you mentioned, I think Max or some other organization will test the case and will test the new privacy framework in front of the court.
Yeah, and I think, I mean, we don't only have the EU. I think what we still should not forget, there's still the United Kingdom that, I mean, they want to change their data protection regulatory environment and setup, but they still have the UK GDPR, and it will be really interesting to see how they will manage that as well. I think, Carlo, you agree that we can assume they will follow suit and enact a similar regulation because they are highly dependent on these kind of data flows as well, right?
Yeah, that's also something I would assume. Yeah.
Good. So we talked about the successor of the Privacy Shield, which will be delivered sometime this year, and it appears rather earlier than later. Another topic we should a little bit discuss in more detail is the new set of SECs. We touched it already a little bit, but to give you some background and flavor around that, I mean, in 2021 in summer, the European Commission, they issued a new set of standard contractual clauses, and they have been mandatory for new contracts since September 2021 already. And the good thing about the new SECs is that they have a modular structure, and now they cover practically all relevant data transfer variants without resorting to very complicated and in particular partly impractical contract constellations we had to come up with in the past. And Carlo, as you have mentioned, up until end of December last year, organizations were supposed to convert all old contracts that still use the standard contractual clauses to the new set of ones. And in personal discussions we here at DataGuard had with various German data protection authorities, Michael Will from Bavaria and Barbara Thiel from Lower Saxony, for example, they have independently stated, look, if you as data controller have not followed suit, and as by now, I mean, it's 2023 already, so the deadline is over, you have not converted your contracts yet, there will be no further extension of the deadline or turning a blind eye, and companies that have not adopted that, they will face sanctions. So, Carlo, a lot of organizations, at least that's what we see, try to be very, very compliant, over compliant. So we see that a lot of data controllers, although they have a transfer mechanism, try to implement several layers to be compliant with the GDPR, with the General Data Protection Regulation, in terms of international data transfers. But is double really better? What's your point of view?
I would say in general, you could say, yeah, double could be better, double or second layer, third layer. But this is also an interesting, purely legal question, because if you're looking at adequacy decision and then the guarantees under Article 46, like the standard contractual clauses, so these two layers, if you will, for me, Article 46 is pretty straightforward and pretty clear when it comes to the question if you can use SCC plus, for example, adequacy decision. Yeah, if you rely on an adequacy decision and then go the extra mile for the SCC, because Article 46 says in the first paragraph, in the absence of a decision pursuant to Article 45. So in the absence of an adequacy decision, controller processor may transfer personal data based on guarantees. So basically, this article already tells you, yeah, you may use me as a guarantee for data transfers, but only in the absence of adequacy decision. So I'm really curious to see if there will, perhaps in the future, we'll see a decision or, I don't know, publication of an authority where they would say something about the relationship between 45 and 46, because from my experience, many companies will do this. They will base their transfers on adequacy decision, but also conclude SCC just to be on the safe side. Yeah. And the question is if that's just theoretically legally possible or not. But of course, also from my experience, I would say with regard to the protection of data, with regard to the also conclusion of contracts and the obligations for the importer in the third country, a second layer of protection would always be better.
Yeah, I do agree that the wording of the GDPR is kind of obvious, and it's also interesting that the EDPB, I mean, and other authorities, individual national authorities, they published a lot on international data transfer, but so far they didn't discuss this topic. Although, as you mentioned, and we see it here with our customers as well, it's highly relevant in practice because a lot of organizations, a lot of data exporters or importers, they rely on SECs, while they also have other guarantees as well. So we talked a lot about international data transfer, and for sure it will be a hot topic this year as well. But let's switch to our next focus topic, regulatory and supervisory initiatives. I mean, we saw in 2022 that major economic powerhouses like the US or India were discussing new nationwide comprehensive privacy regulations that also took the GDPR to some extent into account. And I already mentioned that the UK is debating significant amendments to the present legal regime. And on the other hand, we also saw a lot of fine proceedings by European supervisory authorities. They were very active in 2022. I mean, from January to October, let alone last year, the European watchdogs imposed fines of more than 550 million euros, and that's a lot. At the same time, Google Analytics has been classified as non-GDPR compliant by the CNIL in France. Started with Austria, Italy, and Denmark followed suit over the year. And at the same time, German authorities, they see a great need for improvement in Microsoft 365 and questions questioned its data protection compliance, and that resulted in Microsoft launching its EU data boundary service, which is a good service in terms of data protection, earlier than planned. So we saw a lot of initiatives, but one that kept us quite busy at DataGuard was the letters, the warning letters, the hundreds of organizations in Germany and Austria were facing these waves of warning letters and cease and desist orders regarding Google Fonts last summer and fall. And maybe starting with that, Carlo, in your opinion, or according to your experience, what tips do you usually give your clients when they receive such letters?
Yeah, in general, if you receive such letters, you should, of course, take them seriously and have a look at them, not just put them into the trash, because I mean, not all cease and desist letters are the Google Fonts letters. And of course, you should examine them, and if necessary, also consult legal counsel, lawyer, and get support. Because if you're careless and you act careless with these letters, this can of course have legal and also financial consequences for the organization. So that's the general general focus on these letters and how you would react to these letters. Of course, in special situations, such as those we had with Google Fonts, you at least now would react in another way, because now it has, over the past months and weeks, it has become clear that these were fraudulent scam letters. And now that we know that, if some of our clients still receive these letters, we definitely recommend not to pay the required fees and the money in terms of possible damages of the clients. And currently our answer would be that just to say nothing and to not respond. If the letters also contain an access request from a data subject, you could also reject this request if there's no power of attorney attached to it. And if a power of attorney is attached to it, you could, as a last resort, also give a negative answer for this access request in accordance with Article 15. But I think the current standard procedure would be just to not answer these letters. Of course, perhaps take this opportunity to have a look on your own website. If you really use Google Fonts, and if you use Google Fonts, in which configuration you're using it. So if you're using it remotely or on your own servers, that's something every organization could have a look at and adapt. But currently, we would not recommend to pay the bill, if you will.
Yeah, in terms of Google Fonts, and as you mentioned, taking into account the current court proceedings against the lawyers who issued the respective warning letters and cease and desist orders, but as well against the data subjects that instructed the lawyers. It appears that this is really abusive, but you also pointed out, I think, a very important point that you should really take care of your website and your apps, because there will also be always free riders this year as well, and they will use individual court decisions like in Google Fonts to take action against alleged data protection violations.
Absolutely. I'm pretty sure we will see another court decision this year, or perhaps several other court decisions with regard to, of course, it's always relevant for practice if it concerns a tool used by everyone, if you will, and a tool which everyone outside your organization is able to see that you're using it from your app, the website, and perhaps, I don't know, we will see a court decision for another tracking tool or for the usage of another cookie or, I don't know, a chatbot functionality or whatever. And I think that's something we have to get used to.
Yeah, you pointed out a really important topic. I mean, it's easily possible nowadays to prove data privacy violating configurations or unauthorized tools on websites and apps quickly and, more important for court cases, objectively with little effort, right? There are a lot of tools out there. I'm sure you use some to scan websites of your clients and give them advice. We use certain tools here as well. And obviously free riders will use them as well, or data subjects that are really concerned. One thing I think we need to mention here is still that not every controller is or will be willing and has the time and resources to fight against such warning letters, right? By countersuing the claimants. But what every controller should do, they should take care that websites and apps are compliant, because that's the business card, right? In terms of privacy, everyone can see it, can check it, and if you receive a warning letter, then the first thing you should check is, are the statements true? So please get privacy compliant firsthand, and then think about how to deal with such letters. And if we try to look a bit more into the crystal ball, and you mentioned the topic damages already, I think 2023 will be a very exciting and revealing year in terms of claims for damages, as we will most likely see landmark rulings by the Court Justice of the European Union this year, and this might increase litigation risks. So companies should be alert. To give some flavor on that, I mean, there are currently more than a dozen cases from various European countries before the CJEU, which will set the course for this year. And due to its fundamentally very data subject friendly interpretation of the GDPR, you can assume that it will interpret this important data subject right rather generously and broadly, with the consequence that claims for damages might increase in the future. Would you agree, Carlo?
Yeah, definitely I would agree on perhaps not the fact, but our suspicion that we will see more claims for damages. We also see, at least in Germany, that organizations and companies are specializing to represent data subjects in these cases. Like, I mean, it's pretty straightforward. The business model is pretty simple. You're looking for publications, news articles about data breach or attack by hackers on a company, preferably in the B2C area, where customers and data subjects were affected, and then basically you will try to reach out to these data subjects by announcement on your website, and you will try to sue the company for violations of GDPR and claim damages under Article 82. So basically, parallel evolution as we saw it in the sector of the rights of passengers with regard to flights in the aviation sector. And so, yeah, definitely I would say it's something we have to keep an eye on in 2023. I think for organizations, And also for us, as advisors, lawyers, DPOs, it will be also an important task to raise awareness within organizations and companies for that topic. So, I mean, everyone talks about the 4% and 20 million euros, etc., on the fines. That's of course one issue you have to take care of, non-compliance. But if you look at the at least possible outcome of such claims for damages, if it concerns hundreds or thousands of data subjects suing one company, each data subject receiving 500 euros, 300 euros, that can also be a huge financial loss for a company.
Financial loss, or at least a burdensome process to deal with if you
Yeah.
receive a lot of claims for damages. And I mean, I mentioned there will be landmark rulings. I mean, the CJEU has to decide whether a mere violation of the GDPR is sufficient enough to claim for damages under Article 82, or whether there needs to be, or whether there is a certain threshold you need to meet, and whether pure anger is also sufficient enough or not. I mean, the we have the opinion in one case yet from the general attorney, but it will be really important for all of us to follow suit and see what the CJEU will decide on that, because it really either means a really high increasing risk of damages litigation, or there's a residual risk, but you still might be able to deal and cope with that, right?
Yeah, everyone is waiting for the decision of the European Court of Justice in this respect. And if you would have asked me before the decision or the opinion of the Attorney General was published, I would always have said, yeah, if you look at the European Court of Justice decisions with regard to GDPR, Data Protection Directive in the past, no doubt about it, it will be data subject friendly. And to our surprise, the Attorney General was at least not 100% on the side of the data subjects, but took a different, or at least a partly different view with regard to the question how high the requirements are for claims for damages. And it will be very interesting to see if the European Court of Justice follows this opinion, because as we all know, normally, or in most cases, the court does. If also in this case the court would follow the opinion, it would at least be, let's say, a slightly positive sign for organizations in terms of the question of requirements for claims under Article 82, that at least we have some requirements which have to be taken by the data subject.
Yeah, I do agree, and the decision is really needed, because at the moment we have two diverging opinions. I mean, we have a federal Supreme Court decision in Austria, and a completely different one here in Germany from our federal labor court. So we as practitioners really cannot wait for this decision, and then it will, as per usual, mean more work of raising awareness within organizations, within data controllers. But I think this will be one of the most important rulings to be seen by the CJEU this year. And you mentioned a fact that I wanna cover now, I mean, you said, look, fines are not everything, and I couldn't agree more. And so do German supervisory authorities we spoke with last year. I mean, in our opinion, there will be a rise of new means of enforcement. Dr. Stefan Brink, for example, the former state data protection commissioner of Baden-Württemberg, he said that, look, there will be again many fine proceedings this year, including 8 and 9-digit individual fines, but you have to keep an eye on the damages claim, so Article 82, but also take a look on Article 80 in terms of claims made by consumer protection organizations. And we mentioned the name uh, quite some times already, None of Your Business, the organization by Max Schrems. They have filed hundreds of complaints with various supervisory authorities here in Europe regarding cookie banners and websites violating data protection laws, and will continue doing so this year. And Article 80, to give our listeners some background, Article 80 of the GDPR allows NGOs and other consumer protection agencies to file complaints with authorities and claim damages on behalf of data subjects. And it has been relatively unknown, but at least neglected until last year. But I think things will change, and we will see increased activity by such organizations, in particular, as there was a landmark decision by the CJEU last year on the legal standing of these consumer protection organizations. So in my opinion, and opinion of certain supervisory authorities, there will be a shift in terms of enforcement actions. There will be fines, but organizations really need to look closely how to prepare for damages claims from data subjects, but also initiatives by NGOs under Article 80. Would you agree, Carlo?
Yeah, as already mentioned, I think we will see an enforcement not only on the side of the authorities, but also, if you will, enforcement in the private sector, may be by claiming damages, may be by organizations. As you know, for example, here in Germany, the Consumer Protection Organization, which already was party of that ruling of the European Court of Justice, what you mentioned last year, they are pretty active. And I think it's also good that we have several, if you will, enforcement streets towards GDPR interpretation and ultimately towards the European Court of Justice. Because as we all know, the GDPR as such is partly so broad and so vague in the wording, so that for us as practitioners, we often face situations where we say, okay, I can recommend you to do A or to do option B, but we all don't know if that's 100% compliant because the law as such is so broad and vague. And so I would always prefer and always also respect enforcement and also the clearing open questions in terms of GDPR, may be by the authorities, by the data protection authorities, or may be by private organizations. Absolutely, yeah.
And I don't want to worry our listeners and viewers, but things will get even more complex because there will be a new layer as well in terms of competition law, right? We just saw a recent ruling of our federal Supreme Court here in Germany, asking the CJEU whether competition law or whether the GDPR or European law prevents national competition law to take action if there has been a data protection violation. And our Federal Cartel Office, they in January already took action in terms of Google based on their processing activities. So this will come on top, that we have other supervisory authorities here in Europe that might enforce data protection law, and maybe even competitors being able to sue other competitors over shortcomings in data protection.
Yeah, it's definitely something we have to keep an eye on. It's with regard to the point you mentioned that the European Court of Justice will decide on the question if German or national competition laws allow for competitors to sue each other based on GDPR violations. I mean, we know that in Germany it has a long tradition to do this, yeah, also based on the old data protection laws. But it's, of course, for organizations, to a certain extent, it's insane, if you will. So you have to keep track of many possible risks and possible players in the field. Maybe the authorities, maybe the data subjects as such, consumer protection organizations, or perhaps in the future also your competitor, who may sue you based on GDPR violations. Yeah.
Yeah, I fully agree. And in this respect, it's really key for organizations to have a DPO, a data protection officer, that is able to consult them, and then also either internal legal department or specialists like you, supporting them in finding a balance, right balance and strategy in terms of data protection. Finding a balance, I think that's also something for our last topic, and we really need to talk a little bit about that. It's the upcoming, or they're already going on, EU data initiatives as part of, in my opinion, a new era for the data economy. So we cannot talk about trends and predictions for this year without covering these initiatives as part of the EU Commission's digital strategy. And this will be our last topic. So data has become the new oil, or the most important asset for digital business models, and to allow for easier data sharing and data access, while at the same time protecting critical infrastructure, the EU Commission launched a vast set of data initiatives. So a lot of acts, in particular the Data Act, Digital Services Act, the DEI Act, and the European Health Data Space, together with cybersecurity strategy. So the NIS2 directive just came into force, and there will also be a Cyber Resilience Act. And these acts will be adopted or come into force this year, and will affect how data must be protected and shared with others, eventually forcing organizations that derive any value from personal data to change how they share, protect, or access it. So, Carlo, can you, maybe as a last question, give us a glimpse on how these acts interplay with the GDPR, and how companies should, in particular, prepare for the Data Act? Because, in my opinion, it has the biggest impact on ordinary businesses out there.
Yeah, sure. First of all, from the lawyer's perspective, active in the field of data protection law, IT security law, a big thanks to Brussels and to the European legislator for being so active in this field. No shortage of work for us. No, but to come back to the topic, I think what we see is what you mentioned, the strategy of the European Commission to really create a digital market, a data market in the European Union with various initiatives. Not all of these initiatives have really huge implications on GDPR or on data protection law as such. Most of these acts you mentioned, maybe a regulation or a directive, have their own field of applicability, if you will, and sometimes you will read in these acts something about GDPR and that personal data may be processed also under these acts, but in general, they only refer to GDPR and state that if you process personal data, you have to comply with GDPR, period. One relevant act from a data protection perspective is indeed the Data Act, I would say, because the Data Act, at least from the draft we are looking at now, covers personal and non-personal data. So it also touches upon GDPR issues. And I think, status of today with the draft, there could be a certain tension between GDPR and the Data Act. While the GDPR is, of course, as we all know, intended to ensure comprehensive protection of personal data and the natural persons, the aim of the Data Act is to ensure fair data access and the use of data, personal data or non-personal data. So in principle, the Data Act is intended to complement GDPR and also e-privacy directive, but not weakening data protection legislation. According to the Act, when accessing or also forwarding personal data, the principles of, as we all know them, data minimization and data protection have to be ensured through technologies like the data protection by design, data protection friendly default settings. Whether this can be implemented in practice is viewed partly critically, and we will have to wait and see how this initiative with the Data Act ends up. With regard to the implications for companies or also for public bodies, I think far-reaching obligations follow from the Data Act, in particular for companies to provide access to user data and to pass this on to third parties at the user's request. So there's definitely a tension between Article 20, if you will, from GDPR, data portability, and the Data Act. And under the Act, under the Data Act, it follows that depending on the type of product, service, companies may have to make significant adjustments to ensure this access to data, because currently not all services, not all products have the possibility to access data which is processed by these products. So this is something companies should definitely keep in mind. On the other hand, I think it would be too early to really get into practice and to adjust products and services, because currently we are talking about a draft law with no final opinion from the council, no final statement from the parliament. So Data Act is still in the process, but one should keep an eye on this Data Act, definitely. Yeah.
As it is very relevant for a lot of businesses out there, as you just mentioned. So please follow these developments. It will have a huge impact on how data is accessed and shared in future. And as per usual, the EU is the innovator in terms of regulations. So similar to the GDPR as a role model for international privacy regulations. I think all these initiatives will also be to some extent a role model in how other countries might regulate that. So unfortunately, time's up already. I mean, we could have talked about so many other trending topics that will accompany us this year, like a potential federal privacy law in the US, the current hype, Chat GPT, and regulating AI. I mean, there will be an AI act as well. Or I found it very interesting, the fight between the EDPB and the Irish DPC on how to enforce GDPR on big tech. So there are a lot of other um, um, topics that will keep us very busy. But to wrap up and summarize what we learned today. So we talked about international data transfers in the beginning, and we learned in particular that raising awareness regarding the topic of data transfers was pretty difficult in the beginning, and also to um, keep track in terms of um, adopting and converting contracts to the new set of standard contractual clauses. We talked about enforcement actions and fine proceedings and damages. And we also learned and agreed, Carlo and I, together with other experts out there, that there will be more private enforcement in future, and we will most likely see more kind of class action regarding damages, like we see in the flight industry and flight sector. So this is something companies should really keep an eye on. Together with what we just covered lastly, the developments in Brussels regarding the EU digital strategy. So Carlo, really thank you. A big shout out to you as to today's guest. Thank you for your time, your valuable inputs, and sharing your opinion. And maybe we can do a wrap up session end of this year to see whether our predictions came true.
Thank you very much. Thanks for having me. And sure, let's do a wrap up by the end of 2023.
And to all of our listeners, stay tuned for our next initiatives. And in the meantime, follow DataGuard, Carlo, and me on social media. Then you are secure and always up to date in terms of new developments. And most important, protect the people behind the data. Cheers and see you later.